I don't think a long introduction is needed for the speaker of tonight, but I do want to say a few words. We are still extremely thrilled. I don't know how many years this will last, that we are thrilled with Lady Hale having decided to join UCL as an honorary professor. And I can say that she actually came to us asking whether she could come, and I thought about it long and hard, and then immediately said yes. I don't think she needs a lot of introduction, but I do want to say a few words about her absolutely distinguished career. She's, of course, been a judge for a very long time. She's been on the Supreme Court for a long time. She's been on the Supreme Court for the whole of its life so far. And before that, she was on the House of Lords, the Appeals Committee, and she was the first woman there to, I think in 2003, to join the House of Lords. And then moved to the Supreme Court. She became a deputy president of the Supreme Court in 2013 and became president of that court in 2017 and has retired just last month. Of course, she is one of these absolute role models in the judiciary as a woman reaching the presidency of the Supreme Court. It's a bit late, isn't it, to have you as a role model? We should have had earlier ones, but that does not in any way diminish your achievements. What I also really, I have to say that, what I really like about her career and how she got to where we are today and her achievements is that she actually studied law, because there are many in the judiciary and at the bar who have not got law as a first degree. But you did. In Cambridge, so be it, but certainly something worth noting. And she has been also an academic for many years at the University of Manchester, also something we can accept. For 18 years, has been a law commissioner, first woman to be a law commissioner, a high court judge, only the second woman to be appointed to the Court of Appeal. So she's been seeing all kinds of sides of the law and has been very active at all levels in an absolutely extraordinary career. Under her presidency at the Supreme Court, I think last couple of months is really kind of a last-minute thing that you became a celebrity. I think the way you have is very well timed. With the Miller Cherry cases, I think this is not something any of the senior judges seek to achieve, celebrity status, but it was primarily possibly the Prime Minister's actions who led to that effect. You will all remember, I think, her judgment in the Miller and Cherry case, which was decided in, try to think now, in September, late September. I do remember, because this was the induction day of our LLM students, an absolutely terrible wet day, and I was introducing some issues about the Brexit litigation to the students like half an hour before you delivered the judgment. So it was very well timed on your part to coincide with that. But her contributions, of course, are much more than that. And we're really looking forward in the years ahead to see her around UCL a lot and to try to do things with her. And she's already given a seminar very kindly to our staff and very kindly agreed to give this lecture to our students. So a very warm welcome again to you, and you will be saying a few words about what the Supreme Court is for, which is, I think, an important question, and certainly deserved.
Well, thank you very much indeed. My prediction is that you'll be glad to have me around for about an hour and no longer. Okay, so I said, what is the Supreme Court for? Last year we celebrated 10 years since the Supreme Court opened its doors. So it's worth reflecting on how that came about, whether it was overall a good thing or a bad thing. In other words, what is the Supreme Court for? Until 2009, the top court in the United Kingdom was a committee of the House of Lords. Its judges were the Lord Chancellor, other peers who had held high judicial office, and the Lords of Appeal in Ordinary, known as Law Lords. They were actually called in Ordinary because they were paid. Ordinary is ways and means, basically. These were the first life peers created by the Appellate Jurisdiction Act because there were not enough legally qualified peers to do the work. The Law Lords didn't join the procession of bewigged and berobed members of the judiciary of England and Wales at the service in Westminster Abbey to mark the opening of the legal year. They attended as guests in morning dress, or in my case, a suit and a cute hat. I wore a hat to show that there was one woman at long last amongst them. In 2009, all that changed. The Law Lords became the Supreme Court of the United Kingdom. We joined the procession, wearing our brand new black and gold robes, but no wigs. Though in my case, I still wore a hat, but in this case, a Henry VIII bonnet to keep up the tradition. 10 years later, there's still some confusion about where they should take their place in the procession. What's the hierarchy? But these things don't matter very much. The substance matters a great deal more. Freddie Reynolds, Queen's Counsel, has recently given us an entertaining account of the creation of the Supreme Court in a book called High Principle, Low Politics and the Emergence of the Supreme Court. Now, the high principle involved was the constitutional propriety coupled with constitutional clarity. So senior law lord, Lord Bingham, was its principal advocate. In his UCL Constitution Unit Spring Lecture in 2002, he argued that judges should not be legislators. Although the Law Lords were full members of the House of Lords and entitled to take part in parliamentary business if they chose, they had agreed in 2000 that they wouldn't do so on matters of strong party political controversy. They'd also bear in mind the risk of disqualifying themselves from sitting on a subsequent case if they had expressed an opinion about the subject matter of legislation. So, in his view, the institutional structure should reflect the practical reality. We were a court and should be seen as such. The public and people from overseas shouldn't be misled into thinking that we were also legislators. We do not belong, he said, to a house whose business we can make no more than a slight contribution. There were practical reasons too. We took up a lot of space. I had a whole room to myself, whereas 4 other working peers had to share the identical room space next to me. They may very well have been sorry to see us go as people, but as Lord Wallace of Saltaire put it in the short farewell debate, we don't want to lose you, but we think you ought to go. They weren't sorry to get their hands on the space which we and the Judicial Office occupied. Yet we too did not have enough space. There weren't enough rooms for each of the 12 Law Lords to have one of their own. The only reason that we could manage was that Lord Savile was permanently on, not quite leave, at the Bloody Sunday inquiry. So he could just have a broom cupboard as his room, and the rest of us had actually got a decent room. But without that, we wouldn't have had one for everybody. We shared 4 secretaries and 4 research assistants because there was no room for any more. And we only had first call on 1 committee room, which was large enough for only 5 judges. So much for principle and practicality, but what about the politics? These centred around the threefold role of the Lord Chancellor as head of the judiciary, theoretically top judge of the United Kingdom, Speaker of the House of Lords, and head of a government department. A department which spent a great deal of public money on the courts and legal services. Now, this was increasingly difficult to reconcile with the European Convention on Human Rights, its insistence on the right to a fair hearing before an independent and impartial tribunal, but it was also difficult to reconcile with a spending minister's constitutional accountability to the House of Commons. And the government of the day had long been frustrated by its resistance to change and reform of the criminal justice system in particular. Now, these are all very proper matters of constitutional principle. They don't quite explain why it was necessary to announce 3 major reforms: the abolition of the Lord Chancellor, the creation of the Supreme Court, and the formation of a Judicial Appointments Commission in June 2003 without the Lord Chancellor or the top brass in his department or the senior judiciary knowing it was going to happen. This is not very usual. They were all in conference in Great Missenden in the home counties when someone rang to tell them the news. It seems to have been thought that this was all relatively uncontroversial and that abolishing the Lord Chancellor was just like abolishing the Secretary of State for this, that and the other. It isn't, of course. And of course, our leaving was not uncontroversial. There was a strong element of, if it ain't broke, don't fix it. The three-part role of the Lord Chancellor was anomalous, but what harm did it do in practice? Lord Chancellor Irvine had already said he wouldn't sit on any case concerning legislation in the passage of which he'd been directly involved, nor in any case where the interests of the executive were directly engaged, which is probably more than half our cases these days. His successor, Lord Falconer, never sat at all. There were all sorts of advantages to our being in Parliament, not just the richness of the surroundings. Actually, the carpets are beginning to fray. It's beginning to look a little bit worn. I was there earlier today, and I can attest to that. But the surroundings were very rich, and the staff are very deferential. Great variety of interesting people you can hang out with in the House of Lords. Relative cheapness of the catering. So, all sorts of advantages to being there. But there were some more serious points. Firstly, and this was really serious, in Parliament we weren't dependent on a government department for our resources. Our resources came from Parliament, which has a direct line to the Consolidated Fund. We were now going to cost a great deal more because we could no longer rely on the building, personnel, library and IT services provided in Parliament. Would it really enhance our independence if our finances had to come through the departmental budgeting process, especially if this was linked to the Ministry of Justice, where the courts are squeezed between the demands for legal services and the demands of the prisons and probation services? It took a lot of work in the early days to make it clear that we were a separate accounting body with our own budget, separate from that of the Ministry of Justice, that they would transmit our bid without amendment to the Treasury, and that they would have no control over what we needed and how we spent it. Secondly, while we were in Parliament, might not parliamentarians think it impolite to be too critical of our decisions? You can imagine the members of the House of Lords, they're very polite people, they're self-regulating people, and after all, we were one of them. Once we were on the outside, would they feel freer to criticise us? Would this be an even greater risk now that the law required us to scrutinise not only the actions of government, which we've always done, but also the legislation passed by Parliament? Now, recent events may indeed suggest that this was not a fanciful concern. However, I don't think that Commons ever did regard the Law Lords as one of us, and so I'm not sure that we had quite the same respect from them that we did from the House of Lords. Third objection. Where would the judges and the whole justice system be without the Lord Chancellor to speak up for us at the heart of government? Perhaps only in the United Kingdom could it be thought that the best guarantee of the independence of the judiciary was to have the head of the judiciary, responsible for all judicial appointments and the administration of justice, also a senior member of the government. The guarantee of the independence of the judiciary is to have the head of the judiciary not independent of the executive or Parliament. It's so British, isn't it, that they should think that. But again, that was not an unfanciful concern, because it was the role of the Lord Chancellor, who, albeit a politician, always a very senior and respected lawyer, to defend the rule of law and the independence of the judiciary. This had to be translated into a statutory obligation under the Constitutional Reform Act 2005, and we have had an unfortunate example of a member of the government charged with that responsibility not coming to the defence of the judges as quickly or as firmly as many thought should have happened. And I think you know whereof I speak. Some of the sceptics were persuaded by the famous case of Jackson and the Attorney General. Now, I cannot believe there's anybody in this room who hasn't heard of the case of Jackson and the Attorney General. Yes. Yes, well, you all know that it was about the row between the House of Commons and the House of Lords over the Hunting Bill 2004. And the argument was that the Hunting Act, which resulted, was not a valid Act of Parliament because it had been passed without the consent of the House of Lords under the Parliament Act procedure as amended by the Parliament Act 1949. And the Parliament Act 1949 had been passed under the Parliament Act 1911 procedure. So the argument was that the properly constituted Parliament was the King or Queen, Lords and Commons, and the Parliament Act 1911 had delegated that function to just the Commons and the monarch, and a delegate is not allowed to enhance its powers, and that was what the 49 Act did. We didn't think much of that argument. But the interesting thing about the case is that it was 9 members of the House of Lords who were deciding it. How could we possibly not be judges in our own cause? The fact that we decided it in favour of the Commons is neither here nor there. To any objective observer, we were judges in our own cause. So even sceptics about getting us out of the House of Lords began to see that there were cases where maybe we shouldn't be there. So the Supreme Court was set up by the Constitutional Reform Act 2005. Various models of a Supreme Court had been canvassed beforehand, but Lord Bingham's preference was for the minimalist option. A Supreme Court severed from the legislature, established as a court in its own right, renamed and appropriately rehoused, properly equipped and resourced, and affording facilities for litigants, judges and staff, such as in most countries in the world are taken for granted. And that is exactly what we got. The Supreme Court has brought not only the negative benefits of taking us out of Parliament, but the positive benefit of having its own premises, its own staff, and its own facility for doing its own thing. The building is not as grand as the Palace of Westminster, but it is just as beautiful. I don't know how many of you have been to visit it, but I do recommend going to visit it because not only is it a beautiful building, but quite interesting things go on there. It was opened in 1913 as the headquarters of Middlesex County Council, with the usual accoutrements of a large council chamber, 2 courts for the quarter and petty sessions, committee rooms and council offices. It was also one of the last flowerings of the Gothic revival. Pevsner calls it Art Nouveau Gothic. It has an abundance of exuberant decoration, stone carving, wood carving, stained glass, light fittings and door furniture, all of a period and all of a piece. All of that was kept while we cleared away the clutter of decades and created a light and bright building with the sort of courtrooms in which to do our sort of business. The only problem with the building, the only regret I have about it, is that the court has, as a condition of getting permission to convert the premises, to house the collection of Middlesex portraits. We've been able to counter it with a brand new work of art celebrating the progress of women in the law. So do come along and see it. It's a very beautiful piece of work which has 4 wonderful photographic panels. One commemorates Cornelia Sorabji, an Indian woman, a brilliant Indian woman who was the first woman to study law at the University of Oxford and went on to be an advocate for the women in Purdah in India, very necessary task. Next one is Rose Heilbronn, who is the first woman to be a really, really famous advocate. Next one is me, and about which Lise said. And then the last one is the unknown woman lawyer of the future. So we've gone through the century like that, and it's a really beautiful piece of work. The court is a great deal more open and accessible than the House of Lords used to be. It's much easier to get into the building than it is to the Houses of Parliament. It's not guarded by armed police officers yet. Well, I hope it never will have to be. The staff try to be friendly and accessible to students and interested visitors of all kinds. People just pop in to see what's going on. We do get quite a lot of people who see the signboard, think, oh, okay, can I go in? And they come in, and you're sitting in court, and you're seeing these people who are at the back of the court, and they sort of pop their head round the door, and the security people say, oh, go on, go and sit down. Yeah. So they do that. and they stay about 5 minutes, and then out they go, which is not surprising. There's an exhibition space and a cafe on the ground floor. There's an education programme to help school and college students understand what the court does and how it does it. This includes an Ask a Justice programme. We used to call it Skype a Justice, but other such platforms are available, so we now call it Ask a Justice, but it's done by Skype. And this is for schools who are too far away to come and visit the court, and they have half an hour with the justice where they ask him or her questions and hopefully have a friendly chat. Tour parties of all kinds are welcome. Anyone can come and go. You only need a ticket when it's a very big ticket sort of occasion, of which there have only been 2 in my time at the court. Websites are a great improvement on the parliamentary predecessor. Anyone with access to a computer and the internet can watch our hearings live online and access the archive of earlier hearings. No doubt few people will want really to spend much time watching the hearings because arguments on points of law of general public importance are not exactly Perry Mason or Rumpole of the Bailey or whatever the current courtroom drama is. But millions of people watched the 2 Miller hearings, quite surprisingly, the whole way through. Now the court is no longer bound by parliamentary procedure, it can make its judgments more accessible, not only to the professionals, but also to the public. In the House of Lords, judgment was given in the chamber. Technically, each law lord delivered a speech on the motion that, quote, the report of the appellate committee be agreed to, end quote. Originally, these speeches were read out verbatim and then reported in the law reports. Then a practice was adopted of each law lord saying, for the reasons given in a speech which I have prepared, copies of which are available in print, I would dismiss or allow this appeal, as the case may be. No one watching had the slightest idea what was going on. Speeches were delivered and printed in order of seniority. Although there was usually one law lord who was appointed to do what I call the donkey work judgment, you know, the one that sets out all the boring facts and all the boring law and maybe reaches a result, it was not always apparent who that was. And each law lord was free to write his own standalone judgment. And sometimes you will be aware in some areas of the law, perhaps particularly the law of negligence, you could have 4 or 5 standalone judgments, all reaching the same result for slightly different reasons. Don't you love it? Well, I'll tell you who do like it. The academics love it, because it gives them plenty to write about. And the senior advocates quite like it, because it gives them something to argue about in the next case. I don't think the parties like it much. The courts below don't like it at all. And I would be very surprised if most law students liked it, and the general public must be totally mystified. So nowadays, we can do our own thing. So we have one leading judgment, which commands the support of a majority of the court, and that comes first. So you know which the lead judgment is. Others are free to write separate concurrences or dissents, but separate standalone judgments of the sort you can see in all the main House of Lords negligence cases are discouraged. So it should be clear what the majority have decided and why. And it's also possible and increasingly common to have joint judgments written by 2 or more people. The judgments are communicated in 3 ways. There's the fully reasoned version. That is the only proper one. You're law students. You can't get away without reading the whole judgment. Do remember that. There's also a 2-page so-called press summary, which isn't a press notice, but a deadpan summary of what has been decided. And the author of the lead judgment also does a short oral summary in the courtroom, which is broadcast and is available on our YouTube channel. Have you ever accessed our YouTube channel? Yeah. They're quite good fun, some of them, aren't they? You've probably got your favourites as to who gives the most punchy account of their decisions. But it's always worth going to it first to see how it's being explained to the general public before you go and read the real judgment. Some cases it's not easy to put it over in terms that are going to be comprehensible to the general public, but some of my colleagues really, really relished the challenge of trying to do that. So we try our best anyway. In the recent prorogation case, the judgment had to be prepared so quickly that the press summary had to double up as the broadcast version, but hopefully to the same effect. But has all this changed the sort of court it is? There was a fear that, on becoming a Supreme Court, the law lords would get a rush of blood to the head and imagine themselves to be a Supreme Court like the Supreme Court of the United States. Some people still seem to think that this is so. Why else would we have had the temerity to decide that Parliament had not been prorogued? But emphatically, this is not so. The court is still doing exactly the same job as it did in the House of Lords. With one exception, the jurisdiction remains the same. It is generally a second or even third tier appeal court, hearing civil and criminal appeals from England, Wales and Northern Ireland, civil appeals from Scotland, and devolution or compatibility issues from Scotland, Wales or Northern Ireland. With one exception, cases can only come to the court with the permission either of the court from which they come or from the Supreme Court. Usually the lower court leaves the decision to the Supreme Court. As Lord Bingham put it, the House of Lords dines à la carte. And very tasty it is too, I can tell you. The criterion for giving permission is exactly the same as it was in the House of Lords. The case must raise an arguable point of law. So it's got to be arguable. It's got to be a point of law, not just practice. Only if it's a real point of principle in relation to the exercise of discretion. It's got to be of general public importance, which means that it's got to be important to more than the parties to the case. The fact that it may be worth megabucks is really neither here nor there. There's a sort of final twiddly bit that it ought to be considered by the Supreme Court at this time, which enables us not to take cases which may raise an arguable point of law of general public importance, but which we don't think are the right case in which to raise it. Sometimes because the person's problem has already been solved, so it is moot. Sometimes because we think there may be a point of law of general public importance there, but the parties don't seem to have noticed it. And that is not a fruitful way of going on in our adversarial system. If the parties haven't noticed what the point is, they're not going to argue it, or they're not going to argue it properly, and it could cause ructions. So there we are. But one thing we don't do is give permission where the law is clear and we merely think that the Court of Appeal may have applied it incorrectly. We're not a court of error. We're dealing with these difficult points of law. So there we are. It doesn't, of course, mean that the court gets to decide all the important and difficult points of law. People don't bring lawsuits because an important point of law needs deciding. In fact, that's often a reason why they don't bring a lawsuit. They bring them to get a result. Usually the law is clear enough, but the facts or how the law is to be applied to the facts are not. Litigation is always risky, and it's disgracefully expensive. So litigants will make a cost-benefit analysis even before they begin the case. If they lose at first instance, they'll do the same before appealing for the first time, and the same again before launching a second appeal. And at any point in a civil case, it is open to the parties to settle. So a point which was probably wrongly decided by the Court of Appeal may never get to the Supreme Court because the parties settle out of court, or the loser cannot afford to or doesn't wish to take it further. So don't run away with the idea that we can sort everything out in the law. We are dependent upon people bringing cases before us. But I should say the corollary to that is, if people do bring cases before us that meet our criterion, we've got to take them and we've got to decide them. We don't have a choice. It's the main thing about courts, they're there to decide cases. But the character of cases coming before the court has undoubtedly changed in recent decades, not in the 10 years since the Supreme Court came into being, but in recent decades. Started long before the creation of the Supreme Court. Three main reasons for it. First, since the 1970s, there's been an explosion in judicial review of administrative action. This was partly caused by some groundbreaking decisions about its scope in the 1960s, and partly by the introduction of a simplified and accessible procedure structure in the 1970s. Secondly, of course, under the European Communities Act 1972, the courts not only had a duty of conforming interpretation, to interpret legislation consistently with European Union law, they also had a duty to disregard legislation of all kinds which was inconsistent with directly effective EU law. And thirdly, under the Human Rights Act, the courts also have a duty of conforming interpretation. They can't strike down provisions that are enacted of the UK Parliament which are incompatible with the Convention rights, but the higher courts can make a declaration that they're incompatible. And in deciding whether there is an incompatibility, either in a legislative provision or in actions of a public authority, the courts often have a duty to balance the rights of the individual against the interests of the public. So all three of these developments can bring the court into conflict with the other institutions of government in a way which was not so apparent decades ago. I would say it was not so apparent when I was a law student, and I was a law student in the early 1960s, and that was before any of these things happened. And life was a great deal simpler then. One jurisdiction which did change when we moved was devolution. That was issues about whether the devolved governments and legislatures in Scotland, Wales and Northern Ireland had exceeded their powers. It was thought that these would often be disputes about the demarcation lines between the UK Parliament and the devolved parliaments, and so should not be determined by a committee of the UK Parliament. So on that point, they had got the point. You know, that members of Parliament of the UK Parliament shouldn't be deciding the case. But those same people, no doubt, were still not in favour of our leaving the House of Lords. So they were given to the Judicial Committee of the Privy Council. This despite the fact that exactly the same judges sit in the Judicial Committee of the Privy Council. The only thing was that they sat in a different building, and they used to get into an ancient Daimler to carry them the 200 yards from the Houses of Parliament down to Downing Street, except when it broke down, which it did from time to time, so we had to walk. But it was thought that the institutional separation cured that problem. But once there was a Supreme Court, institutionally separate from Parliament, that was obviously the place where such cases should go. Now, the actions of the devolved institutions can be outside their powers, either because they've acted in a way which is incompatible with the rights set out in the European Convention, or with European Union law, or because they have legislated for something which relates to a subject matter which is reserved to the UK Parliament, or because they've legislated to modify certain specified acts of the UK Parliament or rules of law which they're not allowed to modify. And these questions can come to the Supreme Court in two ways. Normally they come through an ordinary appeal in a real case. The deed is done and a real person or a company complains that it was outside the scope of the devolved powers. A recent example was the Scotch Whisky Association's challenge to the Act of the Scottish Parliament providing for minimum unit pricing of alcohol. They complained that this was contrary to European Union law. It was a disproportionate response to the problem of problem drinking in the west of Scotland. Very, very, very cheap, very, very, very strong alcohol, and lots of alcoholism and so on. So I think the real reason that they were complaining, this is my own private theory, is that minimum unit pricing transfers the profit from the producer to the retailer. Think about it. Anyway, they said the right way to solve the problem was tax, but we said minimum unit pricing was okay. But this was a real case, real parties bringing it up after the deed had been done. Ex post facto concrete review. But these questions can also come to the court by way of an ex ante abstract review, unrelated to a real case. And this is a very new experience for UK court. The law officers of each part of the United Kingdom can refer bills which have been passed by the devolved parliaments but have not yet received the royal assent, for the Supreme Court to rule on whether they are within scope. They can also refer other devolution issues to do with all sorts of stuff, but only the Attorney General for Northern Ireland has been keen to do this. Now, until 2018, there had been 3 references relating to bills passed by the Welsh Assembly, 1 relating to a bill passed by the Northern Ireland Assembly, which was withdrawn, but none at all from Scotland, despite the large volume of Scottish legislation. And it's an interesting political question why the UK law officers were so reluctant to challenge the validity of Scottish legislation. and left it to the parties to do it. I don't know the answer to that, but I think it's interesting. However, in 2018, we saw the first challenge to a bill passed by the Scottish Parliament. In March 2018, the Scottish Parliament passed the UK withdrawal from the European Union, open brackets, legal continuity, close brackets, open brackets, Scotland, close brackets, bill. This provided for the continuity of EU law in Scotland in relation to devolved matters. The Attorney General for England and Wales and the Advocate General for Scotland, he is the UK's law officer for Scotland, not to be confused with the Lord Advocate, who is the Scottish law officer for Scotland. So the Attorney General for England and Wales and the Advocate General for Scotland referred it to the Supreme Court, mainly on the ground that the UK government was planning its own bill in the UK Parliament to do the same for the whole United Kingdom, and they didn't want the Scots getting in there first, or different. By the time the arguments were heard, the UK Parliament had indeed passed the European Union, open brackets, withdrawal, close brackets, Act 2018. And that Act added itself to the list of those acts which the Scottish Parliament cannot modify. So the first question for us was whether we should judge the Scottish Bill at the time that it was passed, before the UK Act was passed, or whether we should judge it at the time when it would receive the royal assent. And the second question was what difference, if any, that would make. These exciting political questions, they were exciting politically, but they involved the most mind-boggling technical analysis of the interplay between the Scotland Act 1998 and the two pieces of legislation, the UK Act and the Scottish Bill. We decided that when it was passed, most of the Scottish Bill was within the powers of the Scottish Parliament, but that it had to be judged not at the time when it was passed, but at the time when it would receive the royal assent. And because by that time the Scottish Parliament couldn't legislate to modify the UK Withdrawal Act, a good deal of it had become outside their powers. Now, in a way, political honours were even. The Scots had been able to do most of what they'd wanted to do when they did it, so the Lord Advocate had been right to advise them that it was okay, but by the time the thing was going to get the royal assent, most of it was not all right, so the UK Parliament got its own way, the UK government got its own way, and in fact the Scots abandoned the bill. I think that was a draw, wasn't it? And a lot of hard work for the court, but I think a very good thing that the court did. Now, this jurisdiction obviously makes the court look more and more like a constitutional court. Not one on continental lines, of a court which is separate from the ordinary courts of law, but on the model of other Supreme Courts in the Anglo-American common law world. The most famous model of such a court, of course, as you know, is the Supreme Court of the United States, but there are similar courts in Canada and throughout the common law world. In a federal constitution, it stands to reason that some court must rule on demarcation disputes between the powers of the state legislatures and the powers of the federal parliament. It doesn't follow that they can rule on the constitutionality of acts of the federal parliament, but in 1803, as you probably all know, the US Supreme Court ruled that it could do so, and other constitutions have followed suit, sometimes expressly, sometimes by implication. In a written constitution, there are also usually entrenched human rights, which the legislature can't take away without special procedures. And the task of the Supreme Court is to strike down laws which do so. But of course, we have no written constitution. The UK Parliament is sovereign, so there can be no question of a UK Supreme Court striking down the acts of the UK Parliament, except to the extent that Parliament itself has given it the power to do so. And in their different ways, both the European Communities Act 1972 and the Human Rights Act gave the courts power to rule on the constitutionality of acts of Parliament. But that is because Parliament has said so, not because the courts have said so. And what Parliament has given us, Parliament can take away, as we have just seen, on my birthday. This more visible role raises more acutely than in the past the question of who should sit to hear which cases. Statute requires the court to sit an uneven number. At present, the court usually sits in panels of 5, one panel in the Supreme Court, another in the Privy Council, or 2 in the Supreme Court. But it does sit at least 7 if it's being asked to depart from previous decision of the House of Lords or Supreme Court, and 9 if it has to reconcile conflicting decisions at that or Privy Council level. The Court also sits 7 or 9 on particularly important or interesting cases. This has been done much more frequently since we left the House of Lords, and the reason for it is perfectly simple. We've got a courtroom where we can do it, and we don't have to ask anybody's permission to use that courtroom for an enlarged panel, whereas, of course, in the Houses of Parliament, we had to ask permission to use a bigger committee room. Practicality makes a big difference to how the world works. Of course, the Court has twice sat in a panel of 11. For the first Miller case, there was a vacancy, so all the then serving justices could sit. For the Miller-Cherry case, all but one of the serving justices sat. I don't know whether the one who didn't sit thought himself fortunate or unfortunate, but he was the one whose travel arrangements were the most difficult to unpick and untangle, and so he drew the long or the short straw, as the case may be. Both cases are further illustrations of why the top court in the country should not be part of Parliament. Both concern the constitutional relationship between the government and Parliament. In the first, as you know, the question was whether the government could use the prerogative power to make and unmake treaties in such a way as to bring about, inevitably it was then thought, albeit wrongly, changes in the law without the approval of an act of Parliament. In the second, the question was whether the government could use the prerogative power to prorogue, that is, suspend Parliament, with the effect of denying Parliament its constitutional role of holding the government to account. The Court sat a full panel in each case, partly because of their great constitutional importance, and partly because it didn't want there to be any suggestion that panel selection had influenced the result. Many, perhaps most, other Supreme Courts sit en banc, but there is a question mark. If the whole Court sits and there's no panel selection, are the politicians going to be more interested in who's appointed to the Court than they would be if there was a random selection of justices hearing the case? That's an interesting question. There's some evidence that in the olden days the Lord Chancellor saw it as his right and possibly even his duty to ensure that the right people sat on certain cases. And this would be unacceptable today. The way in which we do it is the provisional allocation is done by the registry, and it's then agreed with the President and Deputy President in what's known the Horses for Courses meeting. And the aim is to have those with the most relevant expertise together with some randomly chosen others. And all are expected to be able to turn their great legal minds to anything. And in my experience, neither the registry nor the 2 seniors gave any thought to the likely outcome of the case if X sits rather than Y. Well, one of the reasons for that is, we're not that predictable. One of the things that really upsets my American friends is when I say that I don't know the politics of most of my colleagues on the Supreme Court. I can make a jolly good guess, I think, in 2 cases out of all of the justices that I've sat with. It's not a guess. More than that. But everybody else, I could not really tell you which way they voted, and my guess would be that few of them would wholeheartedly subscribe to the manifesto of any one political party. We're not that predictable, certainly not predictable on party political lines, and we're not that predictable on legal lines either. I mean, I could do a little pen portrait of the legal approach to things of most of my colleagues, but even then they're going to surprise me every so often. And that's exactly as it should be. We should be deciding cases according to law and not according to our individual proclivities. So, having said all that, what is a Supreme Court for? Well, my successor, Lord Reid, has said it's got 3 roles. The first is as a constitutional court for the United Kingdom, not a constitutional court in the sense understood everywhere else in the world, but still deciding constitutional issues, etc., etc. The second is to ensure that the laws which apply throughout the United Kingdom, of which there are a lot, are given a consistent interpretation in each part of the United Kingdom. Much of our statute law applies throughout. Tax, social security, welfare benefits, immigration and asylum, equality and employment are obvious examples. Much of the common law is also the same throughout the UK, law of negligence being the most obvious example. Obviously, the answers given to these questions have to be the same throughout the UK. So there needs to be a UK court to do this. And the third role is to stand back from the hurly-burly of the hard-pressed appeal courts, to devote more time, research and thought to the most difficult points of law, but also to be able to develop the law in a responsible and incremental way when times change or the world moves on. The courts of appeal are usually bound by their own previous decisions, as well as by those of the Supreme Court and House of Lords. The Supreme Court is not so bound and can take a fresh look at things. And ironically, the recent case which has most clearly demonstrated the need for a Supreme Court of the United Kingdom is the one which seems to have brought it most under attack. 2 cases brought challenging the advice given to Her Majesty to prorogue Parliament. The Divisional Court in England, headed by the Lord Chief Justice of England and Wales, held that this was a non-justiciable question. The Inner House of the Court of Session in Scotland, headed by the Lord President, i.e. the Lord Chief Justice of Scotland, held not only that it was justiciable, but also that it was unlawful, and the resulting prorogation was null and void. They couldn't both be right. There's only one Parliament. It either had or had not been prorogued. Someone had to sort it out. That is what the Supreme Court is for. Thank you.